Hello, everyone. This is Dan McKenzie with the McKenzie Law Firm. I am an estate planning attorney in the Denver, Colorado area. Our firm does estate planning, estate administration, and small business counsel. I want to make a video today about some common misconceptions we run into about trusts. And there are three of them. And just thought I'd go through them one by one and explain why sometimes trusts don't do what people think they might do. So the number one thing that we run into that people think trusts might be able to provide for them that is not usually the case is asset protection, by which I mean if somebody has put stuff into a trust and then gets sued, are they going to be able to tell people that, sorry, I don't really have any money because my assets are held in this trust? So part of setting up a trust and part of the reason to set up a trust is to actually get assets out of your name, right? So if people go and look at the deed in the county clerk and recorder's office where I live, and they pull out my deed, they're going to see that my house is held by a trust. On paper, I don't own my house, actually. My trust does. So I'm running my trust, so I still, can finance my house or sell it or add people to its ownership or whatever I want to do. But if anybody looks it up, they're going to see that actually I don't own my house. So if somebody sues me, am I going to be able to say, look, yes, I have a house, it has some equity in it, and maybe I could get that equity to pay you what I owe you, but unfortunately, I don't own that house, so sorry. And that is not how this works, right? The trust that holds my house is the most common trust, which is a revocable living trust. And the purpose of a revocable living trust is to get assets out of my name, but for probate avoidance primarily, so that someone else can step in and manage my trust assets if I can't do it for any reason. But I set that trust up. I put those assets in there. I am running that trust. I am the beneficiary of the trust. There really is no one else involved in the equation. So really those assets are still mine. And I can't just do that and maintain full control of my assets while also telling maybe the IRS or the US court system that, sorry, I don't have any assets, so I can't pay my taxes or I can't pay this judgment that was entered against me. There are trusts that you can set up that actually can have those benefits. They frequently have to be set up in certain states that allow for them. There has to be some relinquishment of control, probably. I probably would have to have a different trustee than me. The trust has to be irrevocable. It's not, again, I can't just put stuff into a trust that I control and can amend and suddenly say it's not mine anymore for purposes of protection. So no, revocable living trusts do not give you asset protection from court judgments or from taxes. Number two, most common misconception we run into about trusts is that they don't really require any work to administer. Like if I pass away, my trust assets are just going to pass to the people that I have specified in my trust agreement, and there really isn't going to be any work. And the way that this is most commonly expressed actually is people talk about trusts avoiding probate. And as I said earlier, that is the point. So when I put stuff into my revocable living trust, the point is to enable somebody to step in there, start managing those assets. Could be because I've passed away. It could just be because I've been, hospitalized or I'm having some sort of other incapacity event of some sort where I need someone else to do some stuff for me. And that's kind of the magic of trust is because the assets aren't in my name anymore, someone else can step in and, sign for financial accounts or deal with, my house or whatever else. But if I pass away, the stuff that typically gets done in probate that kind of makes probate a little bit of a pain still needs to be done somehow, right? My trustee can't just shoot those assets out the next day. They should still figure out, do I owe anybody any money? Like, what assets do I have out there? What needs to be gathered? What bills are still coming in? Do we need to pay those bills, or is there some other way to resolve them, or get them written off? Is there a tax return due? Like, all these steps still need to be taken. This is the kind of stuff that happens in probate. So in probate, that is all done under a court process, a court supervision. There are rules that need to be followed, of course. Trusts also have rules. There is a statute in Colorado and in many other states about trust administration, and a trustee still can't just step in and, like I say, just shoot everything out and then tell people that I may have owed money to. Like, sorry, there was no money. He didn't have any money. All that stuff still needs to be happen, and it still needs to happen. And frankly, we've had certain situations where probates were quite easy and trust administrations were quite hard, and vice versa. So I've got a couple other videos out there about what typically makes estate administrations hard. And those things are kind of true whether it's in a trust or not. So for example, If your trustee doesn't really have any cash to work with, and they're being expected to pay bills or file taxes or whatever else, like that's going to be hard, whether or not your house is in a trust or not, or is going through probate. Like not having cash available is going to be a problem. Having the wrong person doing the job, the wrong trustee or the wrong personal representative in a probate process, it's going to be a problem either way. So you just need to not necessarily assume that a trust is going to make everybody's life easier. It doesn't always. Done well, it certainly should. But like I say, we do a lot of probates where it's actually quite easy. And then the last misconception we run into is you have to have a trust to avoid probate. So as I've already mentioned several times, the purpose of trusts are typically to avoid probate, right? Especially the revocable living trust. That is, again, to make sure that assets can be transferred or managed if I'm unable to do it without having to go through a court process. But there's other ways to do that too. Most common ways to do that are to either jointly title things with people who will survive you, or designate beneficiaries, which can be done with a lot of assets. We usually see designated beneficiaries on retirement accounts and life insurance because usually it's part of the process of setting those up is they ask you who should get this if you pass away. So it's very common to see designated beneficiaries on those. But in Colorado and in many other states, actually, you can designate beneficiaries on just about anything that has a title. We have beneficiary deeds in Colorado that you can record for your house saying here's who gets the house if I pass away. There's the Department of Motor Vehicles has a form that you can fill out saying here's who gets my car if I pass away. And then of course banks and financial institutions usually have processes for putting instructions onto accounts about who should receive those. And those are contracts with them. They're gonna, for better or worse, they're going to follow those instructions. So hopefully they're coordinated with everything else. So I'm not telling you certainly to do that or to use those instead of a will. This is usually an estate plan these are all parts of an estate plan. So titling of assets, designated beneficiaries, maybe using a trust, having a will, and then making sure these are all coordinated. Most estate administrations involve a mix of those things. So you just want to make sure you don't have some instructions going one direction and other instructions going a different direction and all that. But point is, again, you don't necessarily need a trust to avoid probate. We have a number of clients who really have thought it through and are like, yeah, I could do this. I could avoid probate and still keep my assets in my name during my lifetime. So those are the three misconceptions: asset protection, making your fiduciary's life easier, or having to use a trust to avoid probate. So if you're interested in having this conversation with us about what the best way to do this is and what you're trying to accomplish, we are happy to do so. Again, we're in the Denver, Colorado area and can help people in Colorado. Our phone number, 833-CO-plans, right? So Colorado Plans is a number that would reach us. Or you can go to coplans.co. That will direct you to our website. And again, we are the McKenzie Law Firm. And so please find us at those spots, and happy to talk. So hopefully this was helpful, and please check out our other videos. Thanks.